Chapter 6 Juristic Perspectives Schools of Jurisprudence. After the age of the companions of the Prophet ﷺ and their eminent successors in the period from the end of the 1st century after the Hijrah to the middle of the 3rd century, there appeared some 13 schools of thought, plural madhahib, singular madhab, in Islamic jurisprudence. They all identified with Ahl al-Sunnah, that is, upholders of the Sunnah school, which was and still is the predominant school in the Muslim world. Unfortunately, only the works of 8 or 9 of the leading scholars or Aimma of these schools have been fully or partially recorded. From these recorded works in their various forms, the juristic principles, that is usul, and methodologies of the different schools have become known. These leading scholars were Abu Sa'id al-Hasan ibn Yassar al-Basri, Abu Hanifa al-Nu'man ibn Thabit ibn Zuti, al-Auza'i Abu Amr Abdul Rahman ibn Amr ibn Muhammad, Sufyan ibn Sa'id ibn Masruq al-Thawri, al-Layth ibn Sa'ad, Malik ibn Anas al-Azbahi, Sufyan ibn Uyayna, Muhammad ibn Idris al-Shafi'i, Ahmad ibn Muhammad ibn Hanbal. There are other Aimma such as Dawood ibn Ali al-Isbahani al-Baghdadi, better known as al-Zahiri because of his insistence on sticking to the manifest, that is Zahir or literal meaning of expressions in the Quran and the Sunnah, Ishaq ibn Rahawayh, and Abu Thawr Ibrahim ibn Khalid al-Kalbi. There are others whose schools of jurisprudence did not spread, or whose followers were not many, or who in fact were considered to be followers of the schools of the more well-known scholars. However, the Aimma whose schools have lasted to this day, who have followers throughout the Muslim world, and whose principles and jurisprudence are still employed in assessing issues and in making legal judgments, are mainly four: Abu Hanifa, Malik, al-Shafi'i, and Ahmad ibn Muhammad ibn Hanbal. Methodologies of the famous scholars, that is Aimma. The three leading scholars, Malik, al-Shafi'i, and Ibn Hanbal, are considered as jurists of Hadith and the established precedents of the companions of the Prophet. Their jurisprudence was that of the people of Medina, whose knowledge they propagated. Imam Abu Hanifa, however, was the inheritor of the jurisprudence of upholders of independent reasoning, that is Ahl al-Rai, becoming the foremost advocate of this school in his age. The difference which existed between the school of Sayyid ibn al-Musayyib, whose teachings were based on the jurisprudence and established precedents of the companions of the Prophet, and which enjoyed the support of the Malikiya, the Shafi'iyya, and the Hanabila, and the school of Ibrahim al-Nakhai, which relies on independent reasoning in the absence of established precedent, this difference was naturally passed on to whoever adopted the methodology of either school. The intensity with which this difference was maintained was reduced considerably, particularly after the Khilafah went to the Banu Abbas, the Abbasiyun, in the middle of the 2nd century. Following this shift of power, the Abbasiyun transferred some of the eminent scholars from the Hijaz to Iraq in order to spread the Sunnah among the people there. Some of these scholars were Rabia ibn Abi Abdul Rahman, Yahya ibn Sa'id al-Iraqi, Hisham ibn Urwa, and Muhammad ibn Ishaq. At the same time, some of the Iraqi scholars went to Medina and studied with scholars there. Yusuf Yaqub ibn Ibrahim and Muhammad ibn al-Hasan studied with Malik. All this resulted in a mutual exchange of ideas between Iraq and the Hijaz. Nonetheless, we find that the three scholars, Malik, al-Shafi'i, and Ibn Hanbal, were quite similar in their methodology, even though they differed in some approaches in using deduction. But the methodology of Imam Abu Hanifa remained quite distinct. Methodology of Imam Abu Hanifa. The principles of Abu Hanifa's methodology are summarized in his own statement. I first resort to the Book of God to find evidence if I am faced with an issue. If I do not find any reference therein, I resort to the Sunnah of the Messenger. May God bless him and grant him peace, and authentic precedents from him which have been handed down by trustworthy persons. If I do not find anything in the Book of God or in the Sunnah of his Messenger, I resort to the statements of his companions, drawing freely upon these as I wish. I do not go beyond this to the statements of others. If the line of enquiry descends to the rank of Ibrahim al-Shabai or Ibn al-Musa'ib, then I am entitled to endeavor to use my ijtihad in the same way as they had done. These are the cardinal principles of Abu Hanifa's madhab. There are, however, some subsidiary or secondary principles which appear to give rise to differences with the other scholars. The general expression is as categorical or definitive in its implication as the particular. The practice of a companion which is at variance with the general practice is taken only as a specific evidence for his practice. The abundance of narrators does not improve the validity or weightiness of the evidence. No consideration should be given to a general proposition which is qualified by way of introducing a condition or a qualification. No acceptance is given to a tradition transmitted by a single person which could harm public welfare. An obligatory command must be acted upon unless there is a constraint which prevents it. If the conduct of a competent narrator is at variance with what he has narrated, do what he was seen to have practiced and not what he narrated. Priority should be given to a clear-cut analogy over the report of a single person, which is in contradiction to it. Juristic preference, that is, al-istihsan, should be adopted and analogy abandoned when there appears the need to do so. Istihsan is the preference given to one rule over another because of its perceived superiority. Abu Hanifa is reported to have said, "We know that this is an opinion and it is the best we were able to produce. However, whoever comes with a better opinion, we will accept it." Methodology of Imam Malik. Malik, may God be merciful to him, adopted a different approach. He is reported to have said, "How is it that whenever someone comes to us with an argument, we abandon what Jibreel brought to Muhammad, God's peace and blessings be on him, and argue with him?" We have already mentioned that Malik's methodology was that of the people of the Hijaz, upholders of the school of Sayyid ibn al-Musa'ib. The principles of Malik's school of thought may be summarized thus in order of priority. Reliance on the unequivocal verbatim text of the Quran. Reliance on the clear or manifest meaning when it is general. Validation of evidence from the Quran of a divergent meaning. Validation of a harmonious meaning. Reliance on the Quran's warnings or cautioning as the effective reason for avoiding anything which is an abomination or is immoral, as in the Quranic verse, "For verily it is an abomination or is immoral and impious." After these 5 principles with regard to the Quran, there are 10 others from the Sunnah in order of priority. Consensus, that is, ijma. Qiyas, the practice of the people of Medina. Istihsan, which involves setting aside an established analogy in favor of an alternative ruling which serves the ideals of justice and public interest in a better way. Blocking the means to evil. Considerations of public interest. Testimony by a companion of the Prophet if the chain of transmission is sound and he is an eminent companion. Consideration of disputed matters where divergent evidence is strong. Presumption of continuity of that which is proven and the negation of that which had not existed. Acceptance of some laws which existed before Islam. Methodology of Imam al-Shafi'i. The principles of the school of thought of al-Shafi'i, may God be merciful to him, are contained in his book Al-Risala, which is considered to be the first and most comprehensive book on the principles of Islamic jurisprudence. Al-Shafi'i says in this book, the Quran and the Sunnah are the original sources of Islamic jurisprudence. If there is no clear evidence in these two, the legist may resort to qiyas from these two. If there is a hadith of the Prophet whose chain of transmission is sound, no other sources shall be consulted. Ijma is more authoritative than the report of a hadith transmitted by a single person. The interpretation of a hadith should be based on its clearly apparent meaning. If the hadith is open to various interpretations, preference should be given to the interpretation which is closest to the apparent meaning. If a number of ahadith pertaining to a special issue are equal in their import, preference should be given to the hadith whose isnad is sound. In this respect, a hadith whose isnad is interrupted, that is munqati', should not be consulted except those reported by Ibn al-Musa'ab. Analogy from a principle, that is asl, which has already been deduced from a previous principle is not admissible. There should be no question as to why or how with regard to the original source. Questions as to why should only be addressed to a subsidiary source of law. If analogical deduction from the original source proves to be sound, it should be accepted as such and as a basis for proof. Al-Shafi'i therefore considered the Quran and the Sunnah as equal in formulating legislation. No condition should be imposed on a hadith except its authenticity and correct chain of transmission, since it is in itself a primary source of law. Consequently, there should be no question as to how or why about a valid source of law. Al-Shafi'i would not impose any condition on a hadith which is well known when it pertains to matters of general necessity, as does Abu Hanifa. Unlike Malik, Al-Shafi'i believes that a hadith need not be in agreement with the practice of the people of Medina. However, he rejects hadith mursal, a hadith transmitted by a successor without indicating the companion who reported to him in general, but accepts the hadith mursal of Sayyid ibn al-Musa'ab because in his case he possessed continuous chains of transmitters. Malik, al-Thawri and his contemporaries among the Ahl al-Hadith, whose specializing in and adhering to hadith differed from Al-Shafi'i in this regard and used such hadith mursal to refute contrary arguments. Unlike the Malikiya and the Hanafiya, Al-Shafi'i rejected istihsan as a source of Islamic law. In refutation of this principle, he wrote a book titled Ibtal al-Istihsan, Invalidating Juristic Preference, in which he made his famous statement, "Whoever argues from juristic preference is making himself the lawmaker." He also rejected the formulation of laws on the principle of the public interest, al-maslaha al-mursala, together with the proofs advanced to support this principle. He rejected the use of analogy that was not based on an effective cause that was established and clearly manifest in the Quran and Sunnah. He rejected proofs based on the practice of the people of Medina. He was critical of the Hanafiya for their non-compliance with many of the Sunnah practices. Because the hadiths on which they were based failed to meet some of their conditions, for example, such as the popularity of a hadith. Finally, he did not confine himself to the hadiths of the people of the Hijaz as Malik did. These are the salient and the most important principles of Al-Shafi'i's school of thought. The differences between them and those formulated by the schools of Malik and Abu Hanifa are quite obvious. Imam Ahmad ibn Hanbal. The principles of the Hanbali school of thought are extremely close to those of the Shafi'i school. These principles in order of priority are: when evidence is available in the texts of the Quran and the Sunnah, he does not consult any other source. If there is a hadith which is raised to the level of authenticity, he does not give priority to any other source, such as the practice of the people of Medina, independent reasoning, analogy, a companion's saying, or consensus based on the lack of knowledge of the questions in dispute. If no text is available on a question, Ibn Hanbal resorts to the juristic judgments of the companions. If he finds a companion's saying which is not contested by other companions, he adheres to this saying and gives it priority over any other practice, opinion, or analogy. If there is a difference of opinion among the companions over a particular issue, he chooses the opinion which is closest to the Quran and the Sunnah and does not go beyond this. If it is not clear to him which opinion is closest to the Quran or the Sunnah, he would report the controversy in complete objectivity and abstain from making any decision. He takes as an authority any hadith, whether mursal or dhaif, whose authenticity in either its chain of transmission or content is not absolutely beyond question, provided it does not clash with an established practice, a companion's saying, or a consensus of opinion. He would give such a hadith priority over analogical deduction. In his opinion, analogy should only be resorted to as a source of law when there is a necessity of passing judgment on an issue which cannot be settled by referring it to any one of the above-mentioned sources and principles. He would adopt the principle of sadd al-dharai, that is, blocking the means to wrongdoing. Methodology of Al-Imam Dawood al-Zahiri. It is perhaps appropriate to give a brief idea of the principles and sources of the Zahiri school of thought, inasmuch as it is one of the Islamic schools which still has some influence and a following among those who uphold the Sunnah. There were serious controversies between this school and that of Abu Hanifa and later Malik, Ibn Hanbal, and Al-Shafi'i. However, Al-Zahiri recognized his great debt to Al-Shafi'i. The salient feature of the Zahiri school is its adherence to the outwardly manifest meanings of the texts of the Quran and the Sunnah. Priority is given to these meanings over any other considerations of alternative interpretation, judgment, or public interest. Followers of this school do not practice analogy and contend that it is only applicable when there is an effective cause or ratio case in a text that can be applied to another case, which, though not covered by the language, is covered by this cause or reason in the text. This means that the existence of an illah is a prerequisite for applying analogy. They prohibit the use of istihsan and only draw upon the ijma arrived at during the time of the companions. Unlike the Malikiya, the Hanafiya, and the Hanabila, they do not use any hadith which is mursal or munqati. They do not accept the validity of any laws previous to the Quran, and they do not allow anyone to apply independent reasoning on the basis of the Quranic verse. Nothing have we omitted from the book. According to this, they argue that the laws are expressly stated in the original sources and that to disregard this is to transgress the limits set by God Almighty. They consider that following the rulings handed down by a given school is prohibited to the common man as it is to the scholar, and that every adult Muslim has the responsibility of striving to learn the correct ruling by himself. It is true to say that many of the principles which are attributed to the leading jurists do deviate from their actual statements and are not corroborated by authentic reports. These baseless principles are then adhered to and defended against any criticism or opposing view. All this gives rise to constant controversy and ultimately detracts attention from the Quran and the Sunnah. This is one of the main causes of pernicious controversy which the Aima themselves never intended. Latter-day Muslims have drifted far away from matters of high priority and have become engrossed in trivial matters. This accounts for the low depths to which Muslims have sunk.